Welcome to our Bowman's webinar, which is going to be dealing with employment law considerations in a business rescue context. First of all, let me introduce myself. My name is Juliette Hutton, and I'm a partner at Bowman's in the dispute resolution department. For the 20 years or so have specialized in insolvency, business rescue, and restructuring. I regularly act for both business rescue practitioners and liquidators. Before I introduce you to our panel, I'd like to just run through a few housekeeping matters which will hopefully enhance this webinar experience for all of you. As participants, you are automatically muted and the chat functionality has been disabled. So should you have any questions during the webinar, please make use of the Q&A tab at the bottom of your screen. Your questions will be submitted to me as facilitator, and towards the end of the webinar, we'll select a few of those questions to discuss with the panel. Please also note that we will not be providing written responses to questions. And then finally, this webinar is being recorded and a copy will be made available on our website later today. Our website, for those of you who don't know, is www.bowmanslaw.com. I understand a recording will also be emailed to everyone who registered for the webinar. Then just a preliminary comment. We've had a look at the sort of profiles of the people who've registered for this webinar, and it varies quite considerably. So there will be some of you in the audience who are fairly familiar with business rescue and what it involves, and others who are not. So we will do our best to pitch this at a level that keeps everybody comfortable, but please do feel free to ask questions if anything isn't entirely clear to you. Although I think 2 hours has been set aside for this webinar, we certainly won't be presenting for 2 hours. The main presentation won't be more than an hour, and then we will have ample time, of course, for questions at the end. So then, to introduce you to my panel, I'm joined today by some of my colleagues. First of all, we have Adam Harris, who's also a partner in the firm's restructuring and insolvency team. Adam's been in practice for more than 35 years, and he advises lenders and companies on their restructuring and insolvency practitioners, both locally and internationally, for example, in recognition applications and recovery of assets. And Adam is a past president of Insol International. Then I have Rosalind Davey, who's a partner in the firm's employment and benefits team. She's been in practice for 18 years and advises companies on all aspects of employment law matters, including retrenchments, collective bargaining, and business transfers. And then finally, Nikita, Reddy, who is a senior associate in the firm's employment and benefits team. And she specializes in employment and public law with a particular focus on dispute resolution. Nikita is a seasoned litigator and she argues matters in the CCMA, the Labour Court, and the Labour Appeal Court. So let's get into the subject matter. One of the key aims of business rescue proceedings is the preservation of jobs. And our legislature, in formulating the New Companies Act and the Business Rescue chapter of that act, made a concerted effort to ensure that the rights of employees are protected throughout the business rescue process. The interpretation of these legislative provisions, and in particular the ability to embark on a retrenchment process during business rescue, has been highlighted over the past year, particularly in the course of the business rescue proceedings of SAA, on which there was quite a media spotlight. And in today's session, we're going to explore the practical impacts of the SAA judgment and some other employment law related aspects of business rescue. So before we get into the nuts and bolts of the SAA judgment, Adam, could you give us a brief overview of the rights of employees generally in business rescue and just a little bit more background on how business rescue works in relation to employees?
Sure, thanks. Because I think what's important is to get a proper view of business rescue and the effect on the employees. You need to understand two things: where we came from in the pre-business rescue era, and also what other alternatives there are to business rescue. I'm going to contrast the position on insolvency or liquidation with that in business rescue as well. We saw from some of the questions that the broad application of business rescue has also been queried. So at the outset, what we must take into account is that the Insolvency Act that goes back to 1936, really has harsh consequences for employees. And remember that the Insolvency Act also applies to companies. And that's even after the Act was amended in 2002, which is quite a noble attempt to bring some sort of fairness and equity into the scenario. But in terms of the Insolvency Act, as we stand at the moment, the position is that contracts of employment are suspended, not terminated, and that's with effect from the date of the granting of the sequestration order. If the trustee or the liquidator of the employer wants to retrench or dismiss, he or she is obliged to consult. Well, so far acceptable to us. During that period, the employee is not required to render services. And of course, the corollary is that the employee is not entitled to be paid either, and they can claim unemployment benefits. That suspension lasts until 45 days after the appointment of the trustee or the liquidator. That's the final appointment, upon which milestone the employment is terminated. So if the liquidator does nothing, those employment contracts are automatically terminated once the 45 days have run. The other thing that one must bear in mind, particularly in negotiations where insolvency is threatened as the alternative, you will probably know that there are statutory provisions regulating what the claims are that the employees are entitled to. The preference claims portion, which is very often all that the employees could bargain on, these amounts are absolutely minimal. So that's the background on insolvency. And when threats are made of business rescue, if you don't like that, there's going to be a liquidation. It's a very serious threat. And as you can see, as far as the employees are concerned, the consequences can be devastating. So now let's compare and contrast that with the 2008 Companies Act. There's a universe of difference. Business rescue, as we know, is dealt with in terms of Chapter 6 of that Act. Can I perhaps just contextualize this for you? Just a few words about business rescue. The objects and purpose of business rescue proceedings are set out in two sections that I would like to highlight, 7K of the Companies Act and 128 of the Companies Act. 7K records that the purpose of the Companies Act is, amongst other things, to provide for the efficient rescue and recovery. So now we know we're into a rescue scenario of financially distressed companies. So it's not for every company, it's one that's financially distressed, in a manner that balances the rights and interests of all the relevant stakeholders. And that's where the employees come in. So Section 128, the second one that I said was important, explains what business rescue proceedings are. And if I can just highlight that quickly to give some additional background. It's a mechanism to facilitate the rehabilitation of a company which is financially distressed. So that's the one concept. How does it happen? Well, providing for a temporary supervision of the company, and I must emphasize temporary as the key word there, a temporary moratorium on the rights of claimants. That means that there can't be enforcement actions against the company whilst it's going through the business rescue process. And ultimately the development of a business rescue plan, this with a view to rescuing the company. And how do we do that? Well, by restructuring the company's affairs in a manner that maximizes the likelihood of the company continuing on a solvent basis, or if that's not possible, then getting a better result for creditors. So how do you start your business rescue process? Well, there are essentially two inbound routes to place the company in business rescue. It could be done either by way of a resolution by the company, that's the board, or by way of an application to court. And the court application will take place by affected persons. Affected persons, again, as defined in 128, includes a representative trade union and any unrepresented employee. That's important. Any unrepresented single employee is an affected person and is afforded the rights, which we'll touch on, that the Act has afforded to affected people. Section 131 is the other route in, other than the voluntary resolution. And that's where a court can make an order placing the company under supervision if it's satisfied that the company is financially distressed, or if the company hasn't paid over any amount with respect to employment-related matters. Any amount. So if there was a deduction, UIF, PAYE, whatever, and not paid over, that in itself is sufficient for the employees to go to court and seek business rescue. And it has to be otherwise just and equitable. In all these cases, you would still need to show that there is a reasonable prospect of rescuing the company. So think about it this way, that gives an edge to the employees in that they not only base the application on the financial distress cause of action, which is more technically challenging to prove, any one payment that's not made, that could found an application. There's another one that's interesting, and I haven't come across this often in practice, but bear in mind provisions of the Companies Act, Section 31. That provides that a trade union must be given access to the annual financial statements of a company, specifically for the purpose of being able to initiate business rescue. So it's a very powerful tool in the hands of the trade union to be able to get hold of the annual financial statements. So let's have a look against that background. If I can tabulate them, what rights do the employees have? And essentially, they're entitled to notice of the meetings and relevant events. They're entitled to participate in court proceedings, even, again, one single employee. They can form an employees committee. They are entitled to consult with the practitioner in the development of the business rescue plan. As I said, that's the apex of where the business rescue is going. They can make submissions at a meeting to vote on the business rescue plan, and they could even propose the development of an alternative plan or acquire the voting interests of one or more affected persons. So, of great importance to the position of the employment, we know that the practitioner does not have the power to suspend provisions of an employment contract. That's hugely important. What you find them, what you have is what you find them as. The employees, in other words, will continue to be employed during business rescue on the same terms and conditions. And it's subject to 3 points. Any changes occurring in the ordinary course of natural attrition, as those people who resign are not reappointed. Any agreement between the company and the employee in accordance with labor laws. And we'll analyze these exceptions in more detail in the course of the discussion. But overall, it goes without saying against that background that employees have been given a hugely significant role in business rescue. Their participation in the process and their support for the process is absolutely crucial to its success. Juliette, back to you.
Thanks, Adam. That gives us a useful background. And I, excuse me, completely agree with you that the participation and support of employees is crucial to a successful process. But from an employee's perspective, obviously the commencement of business rescue proceedings creates huge uncertainty and concerns for job security. It's incredibly stressful for employees. Most of them will be unfamiliar with the business rescue process and will need to be guided quite sensitively and gently through the process. And I think we've all learned from our experiences that open, transparent communication with employees is critical from the get-go. But obviously, one of the first things that comes to mind for employees is the prospect of retrenchments. And this is often an inevitable outcome of the process. And there's no point in avoiding this unfortunate reality when a company goes into business rescue. Employees generally need to be aware that if appropriate arrangements can't be made, if appropriate retrenchments can't be done, then the liquidation of the company could be the only alternative. There's been a lot of debate in business rescue circles over the past year when it comes to the timing of retrenchment proceedings, particularly in relation to the timing of those in relation to the business rescue plan. And a lot of us are familiar with the decision by the Labour Appeal Court in the SAA matter. And in that, they said in short that a business rescue plan needs to be in place before any retrenchment process commences. Now that creates quite a few practical difficulties and has been quite concerning for business rescue practitioners, particularly as a result of the delay that this can cause in being able to commence and effect retrenchments. And that obviously has a knock-on effect to the cash flow and the financial position of the company. So with that in mind, I think we've all been pondering this decision and trying to come up with creative ways to be able to commence retrenchment processes as soon as possible. Ros, if you could possibly come in here and remind us what the court said in the SAA judgment and explain how much room there is to maneuver in light of that judgment. We've all heard various ideas about how one overcomes the consequences of that judgment, some ideas being better than others. So for example, some people have said they think you can commence the process so long as you don't actually effect terminations or retrenchments before the plan is in place. Could you talk us through this and the possibilities?
Sure, thanks, Juliette. Morning, everyone. So before I go into that, I just want to step back and just give some context to what happened in SAA for those of you who don't know the judgment. So essentially, I think we're all aware that SAA has been having financial difficulties for quite some time. Towards the end of 2019, the SAA took a decision to commence a retrenchment exercise, and this arose out of the fact that the SAA was looking at ways in which to secure its financial future. And they issued the Section 1893 letters, which are the letters that commence a retrenchment process. Shortly after issuing the 1893 letters, the business was placed in voluntary business rescue. And when the business rescue practitioners, or BRPs, came in, they took a decision to withdraw the 1893 letters and to stop the retrenchment process. So they came in and the retrenchment process was then halted. Unfortunately, there was a significant delay in the drafting of the business rescue plan, which I understand is often a case in business rescue. And as a result of this, the business rescue practitioners decided that they were going to restart the retrenchment exercise. And the reason for that is that they were looking at how they could save the business and ensure that the business became financially viable. And I suppose it goes a lot to Adam's point that one of the things that the business rescue practitioner has to do is show that there's a reasonable opportunity of business rescue succeeding. So the business rescue practitioners then issued the Section 1893 letters, and they sought to commence a consultation process. I think they actually even approached the CCMA to do a facilitated process. The unions, however, refused to participate, and they said that the issuing of the Section 1893 notices was premature and it was unfair, and that they did not need to participate. And their argument arises out of Section 136(1) of the Companies Act. Now, this section provides that during companies' business rescue proceedings, employees of the company immediately before the commencement of business rescue are protected from changes to terms and conditions of employment. So their terms and conditions of employment are required to stay the same. And there are certain exceptions to that. So if there is a change in the workforce due to natural attrition, if there are agreed changes to terms and conditions, and then it also envisages retrenchments, but the retrenchments must be in accordance with the business rescue plan. So the union's argument was that there had to be a business rescue plan in place. The business rescue had to envisage retrenchments, and absent that, the process was unfair and in breach or in conflict with the Companies Act. Now, the business rescue practitioner says, no, this can't be the case. And they argued that the use of attrition, ordinary attrition, would include retrenchments. So it was really that point that the court had to consider. And the Labour Court ultimately, having gone through it all and having applied the rules of interpretation to the Companies Act, agreed with the union's interpretation. And they said that, firstly, attrition, as referred to in the Companies Act, specifically deals with resignations, terminations of fixed-term contracts, voluntary retrenchments or retirements, and then a compulsory retirement, employees reaching retirement age. So they said that attrition cannot apply to situations where the employer or the BRP is retrenching. Obviously, attrition also deals with misconduct and poor performance dismissals. So the SAA was dissatisfied with this judgment and took the matter on appeal to the Labour Appeal Court. And ultimately, I think, as Juliette said, the Labour Appeal Court confirmed the Labour Court's view and took the position that the Companies Act does not allow for retrenchments unless they are envisaged in the Business Rescue Plan.
And Ros, what do the judgments say about the form that plan must take? Can it be a draft form? Can it be published but not yet adopted? Or must it be an adopted in place business rescue plan before a retrenchment can commence?
We've analyzed this in quite a lot of detail, and Juliette, you're right in saying that a lot of people have been pining on it and discussing it in order to see if there are ways that you can commence the retrenchments prior to the final business plan being in place. Now, in the Labour Appeal Court, in the Labour Court, the judge actually suggests that the plan could be in draft form. So although he doesn't make a definitive finding, what he says is, it is not necessary for me to decide whether the end of business rescue as defined in section 132 triggers the right to commence retrenchment processes. It may well be that the production of a business rescue plan, even in draft form, is sufficient. So the judge considers that that may be a possibility, but the judge does not definitively deal with that or rule on it, because in the SAA case, there was no draft plan in place. So the process commenced even before the draft plan had been presented. The Labour Appeal Court, in considering this issue, however, says that the words contemplated in the company's business rescue plan, in my view, signifies the existence of a corporate rescue plan, which would conceptualize the commercial rationale for the retrenchments of the employees. So when one considers that, it would appear that the attitude adopted by the Labour Appeal Court is that there must be a definitive plan in place. The Labour Appeal Court then goes on to say, where the rescue plan, which contemplates retrenchment, has been approved, the envisaged retrenchments would have to be conducted as prescribed in the Labour Relations Act. So it would seem to me that although there's no definitive answer on it, it is pretty clear what attitude the Labour Appeal Court adopts, and that it will ultimately be required that a business rescue plan be approved and in place before the consultation process can commence. And then to your other question, or the other debate that you mentioned, that there were debates about whether or not section 136 says you can't retrench until after the plan is in place, but you can commence the process. I think the SAA judgment is very clear there. You can't commence the process prior to the business rescue plan being put in place. So the issuing of a section 1893 letter in the absence of a business rescue plan would be unfair and in conflict with the Companies Act.
Thanks, Ros. Adam, do you agree with the finding of the Labour Appeal Court?
Look, I agree that that Ros has correctly interpreted what the finding is, and that there's no doubt that's what the pronouncement of the Labour Appeal Court is to be read. But quite frankly, a draft or a plan that's merely been published has got no relevance. That plan's not binding until it's been placed before the creditors for their consideration. And the creditors have, and the shareholders, of course, have voted on the plan and voted in favour. I don't think that the court should have come to this conclusion. I can't fault it technically, but how you can commence the retrenchment process on the back of a plan, it's a potential nightmare for the practitioner. Because look at it this way. Firstly, that argument is circular in nature. Secondly, remember that plans are seldom published within the intended time period. The Act contemplates completion within 3 months in terms of Section 132. But it does seem to me that the BRPs have a point about the retrenchment process then being in the hands of the voters of the plan. It's a circular argument, because we know that once the plan has been adopted, it can't then be amended by the BRP in any material way without the approval of the creditors. And if I understand the retrenchment provisions in the LRA correctly, there's a duty on the employer to keep an open mind and not to have come into the consultations with a predetermined outcome. So surely then, if the approved plan says, for example, that the company needs to slash 20% of the employment opportunities, and it identifies those positions, and the rest of the plan is based on the assumption that the dismissals will occur, that BRP needs to give effect to it, and can hardly keep what I suppose would be required as an open mind during this consultation process.
Ros, I'd like to hear your thoughts on this from an employment law perspective, and also, the circular argument, and whether publishing a plan that contemplates retrenchments isn't in fact just a fait accompli, which would breach the Labour Relations Act. But when you answer that question, perhaps you could also address something that's come in on the Q&A, which I think is also relevant at this stage. One of our participants says, in the SAA case, would the outcome be different had the BRP elected not to withdraw the Section 189 notices that were in place prior to SAA being placed in business rescue? So in other words, if there had already been a pre-existing process that had kicked off prior to business rescue, how would the courts have viewed that?
Thank you, Juliette. I'll start with that question before I'm going into the issue of retrenchments. So the SAA judgments don't pronounce on that issue. So they haven't given any indication on whether or not that would be sufficient. There was, however, an earlier judgment in the Van Kem case prior to the SAA judgment. And in that case, the process had been commenced prior to the company going into business rescue. And there was also a draft plan in place. So there were differences in that case. But in that case, the Labour Court said there was nothing wrong with the process, and that there was nothing in the Companies Act that precluded that. So that decision has not been overturned by the Labour Appeal Court in the SAA judgment. The difficulty I have, though, with that is that once again, if you go to a technical interpretation of the Companies Act, the Companies Act says that there can only be retrenchments in accordance with the business rescue plan. So it may well be that any process that may continue and that may have started is ultimately found to be unfair. So at the moment, it's a bit up in the air. I do think that there is an argument that a process that has been started should be allowed to commence, but at this stage, we don't know what the court will ultimately say. I suppose one of the things for consideration will also be, when did that process start? So if the process was a legitimate attempt to avoid business rescue and to save the business without going into business rescue, and it had been going on for a period of a couple of months or whatever the end was, and was almost at the end when the company goes into business rescue, then I think you would have a far stronger argument to say that that process must continue than if you, for example, issue 1893 letters the day or a week before you go into business rescue. I suppose there will also be a question of whether it's voluntary business rescue or compulsory business rescue, because conceivably, and Adam, please jump in here, but conceivably you can start your whole process and then go through your 60-day consultation process and then have the unions or an individual seeking to place the business in business rescue, which then could undo the whole process. And I think it would be very important for the courts not to allow circumstances like that, where business rescue is used as a way to either delay or prevent retrenchments. But Adam, I'm not certain if I actually have enunciated that right, or if you have any views on that.
No, I think I'd agree with that. And the difficulty is that it becomes a result, not a cause. And it is indeed possible for the employees, as I said at the start of this program, this webinar, what the rights are of the affected persons. And the employees could most certainly, individual employees or represented by the unions, bring a formal proceeding, absolutely.
So, you know, with that in mind, I think we're going to see different circumstances arising, and depending on the circumstances, it will really result in what the courts, I think, ultimately find. Then on the issue of retrenchments, as you're all aware, when you're dealing with mass retrenchments or your large-scale retrenchments, Section 189 capital A applies. Now, that section envisages effectively a 60-day consultation period, and then your statutory or your contractual notice, so let's say a month. So you're looking at 3 months after your 1893 letters are issued before you can retrench, which creates further difficulties, because if there is a delay in the issuing of a business rescue plan, and then only after the business rescue plan has been issued or agreed or approved, you start the 189 process, it's going to be another 3 months before you can actually start getting employees out the door and off the payroll. Now, as Adam rightly said, the point behind a retrenchment consultation in terms of Section 189 is that you consult. It's an attempt to engage meaningfully, to ultimately avoid retrenchments if at all possible, but otherwise to agree to the issues and to selection criteria and all of those sorts of things. So unless the business rescue plan is very carefully crafted to give the flexibility, there is a risk that there could be an argument that any retrenchments were in fact a fait accompli, because they were just, it was just the business rescue plan being put into place. So it does create great difficulties there. And I think for business rescue practitioners, they're going to need to be very careful how they draft those business rescue plans so that argument cannot fly. But I do understand that in itself could create uncertainty, because creditors and lenders are unlikely to be happy if the business rescue plan is in any way vague. So it does become problematic. The other problem is it possibly results in a double consultation, because firstly, there is the need to consult on the business rescue plan. And I understand from Adam that is includes unions and employees. So there needs to be a consultation on what the business rescue plan entails, and therefore whether or not there's going to be retrenchments and how those are going to work. And then once the business rescue plan has been implemented, then you've got to start your Section 189 consultations. And then you've got to consult on exactly the same subject matter post the issuing or post the business rescue plan. So it does become very circular, it does become problematic, and it results in significant delays. One of the issues that we've considered, or one of the options we've considered, is the whole issue of voluntary agreements. So the Labour Appeal Court and the Labour Court were both of the view that there is no need to have a business rescue plan in place to engage in consultations over a voluntary retrenchment process or early retirements or voluntary changes to terms and conditions. And in fact, Section 136 envisages this because it talks about changes by agreement between the parties. So it may very well be that there is a need for the employers and business rescue practitioners to engage with their employees on the on voluntary MSA, a voluntary process. And that might be the best way if you've got a workforce that is willing to engage.
And on that topic of engaging, Ros, I assume that where you look at a large-scale retrenchment, which would require a 60-day consultation process, is also scope for agreeing a more truncated process with your workforce, which would obviously limit those delays.
That is correct. So the position is, or the legal position is, that you cannot agree out of the 189 process. So the steps that are set in the 189 process need to be followed unless there's an agreement to voluntary retrenchments during that process. But you can agree to shorten the time periods. So it is something that is available, but that would obviously be once you've started the consultation process. I suppose conceivably you could possibly get that agreement up front and even before the business rescue plan is in place, just to say, in the event that we need to conduct retrenchments, let's agree to shorten them. But it remains to be seen how the courts will interpret that. It may just be safer to have those discussions both pre and post business rescue plan, and then ultimately reach the agreement on timing during the actual consultation process.
Yeah, Adam, any thoughts on that? Obviously, the more delays you have, the more risk there is for the company who is in a rescue process.
I mean, there are two things, and it comes back to the circular nature of the court's pronouncement that you need an approved plan. And just for interest, we've had discussions with a number of quite senior business rescue practitioners, and everybody shakes their head, shrugs their shoulders. We don't see as yet a practical way of dealing with it if one has to follow that judgment entirely. And another concern that comes to mind, and I think this was raised by Martin Baumgartner in the questions, the ongoing cost to the company, which ultimately is going to be picked up by your post-commencement finance provider, potentially perhaps the existing lenders to the company, and whether the company can actually afford to incur this sort of salary expense month after month until such time as the plan is adopted. I mean, we all appreciate that rescue proceedings are intended to be a temporary process. And if you follow the strict adherence to the timelines in the Companies Act, the entire process should be completed within 3 months. Now, practically speaking, that doesn't happen. But the point is that the practitioner has to secure a source of funding to keep this whole show going whilst things are happening in background. And if you're saying that you need to get to an approved plan point first and can only then move on the retrenchments, you're going to add months to the process.
Indeed. So if we sort of summarize what we've discussed so far, it does seem like business rescue practitioners' hands are tied somewhat in terms of being able to kick off a retrenchment process prior to a business rescue plan being adopted. But it does seem that it's possible to engage with employees about cutting costs in other ways before there is an adopted business rescue plan. So things like possibly salary reductions, short time measures. Ros, can you go into that in a little bit more detail for us, please?
Yes, so as I said, the Companies Act very specifically allows for agreed changes. So as I think we all know, you can't, as an employer, unilaterally change your employees' terms and conditions. You are required to pay them their salaries, and you're required to try and continue business as usual. However, if you are in dire financial straits, it does allow for collective bargaining. So if it's a unionized environment, depending on which union you're dealing with and the relationship with the union, it may be possible to engage in some form of collective bargaining to try and reach agreements, ultimately to save the business. So it won't be part of a 198 consultation process. It would be a negotiated process. And there it would be at negotiating voluntary severances, maybe reduced hours with reduced pay, different terms and conditions, all of those ways in which the parties can seek to save the business. And I suppose the biggest the biggest risk to employees is if they don't engage, if they don't see sense, there is a risk that there's going to be a liquidation. I mean, you know, the whole aim of trying the business rescue route is to save the business. And if they are unable, or if the practitioner is unable to ultimately bring the cost down, restructure the business and save the business, then there's a very good chance of a liquidation, in which case the employees will lose their jobs, all of them. So there is an incentive for employees to engage in collective bargaining. It then also decides, you know, what process are you going to take? I mean, collective bargaining usually foresees that you then go into some form of a lockout. Now that might not be possible. So where you lock employees out, that is the converse to a strike. It's where the employer shuts its doors and say, you're locked out until you agree to our demands. And our demands are you accept changes to terms and conditions, you accept reduced hours, you accept a reduced pay, and you lock the employees out, then the no work, no pay principle applies. Difficulty with that sort of lockout is you can't employ replacement labor. So it means shutting your doors for the duration, which in itself could be problematic, because if you're not carrying on business, you're not earning, you're not bringing in any money. So once again, that is a bit difficult. And I've only seen lockouts in very, very few instances. So, ultimately I would, maybe not go the step of a lockout, but certainly engage with the unions and explain to them that the potential consequences if no agreement is reached. Now, historically, we've been reluctant to start these kinds of discussions before starting a retrenchment process. And the reason for that is it once again goes to this issue of a fait accompli decision. So if you engage with your employees in voluntary retrenchment discussions or changes to terms and conditions, and then when they don't agree, you go into a retrenchment process and dismiss them for operational rationale, there is an argument that any dismissals are automatically unfair because they are dismissed because they refuse to accept the changes or the proposed changes. This decision, however, was, or the decision of the Labour Court in the Aveng Trident case, which it went all the way to the Constitutional Court, ultimately found that if there is a valid operational rationale, you can still retrench, and it is not automatically unfair dismissal. So that has given us some scope there to maneuver.
I'm just having a quick look at the questions that have come in to see if any should be addressed at this stage. Ros, there was a question saying, what would the situation be before a court grants an order to put the business into business rescue, i.e. need to cut costs by effecting, amongst other things, putting employees on temporary layoff? Now, I assume, obviously, prior to business rescue, you just have the normal provisions that apply, and certainly negotiating changes with employees to avoid the need for even going into business rescue would be first prize.
Well, prior to business rescue, you can also just follow 189. There's nothing to preclude you from issuing your Section 1893 letters, from consulting, and from retrenching. The real issue comes in once you go into business rescue, and that's where the uncertainty and the difficulties arise. So otherwise, what I would do if you're trying to avoid business rescue is issue your 1893 letters and then engage in the consultation, and then as alternatives to compulsory retrenchment, you can offer voluntary retrenchments, early retirement, you can offer reduced salaries, you can offer changes to positions or a restructured organization, so new positions, etc. You would need to show again that there is a legitimate and valid operational rationale. Be very careful once again that it doesn't look like you're trying to use 189 to negotiate new terms and conditions because of the automatically unfair dismissal provisions. But it certainly is possible if done appropriately, and it would then be that would be the remedy there. And if you can get the process done prior to business rescue, then I think that's probably first prize.
Absolutely. Okay, so there's one other big issue we want to talk about, and that is the implication of the moratorium on legal proceedings in an employment context. Now, Section 133 of the Companies Act provides that during business rescue proceedings, no legal proceedings against the company may be commenced or proceeded with in any forum, except in certain very limited circumstances, which would include legal proceedings undertaken with the consent of the business rescue practitioner or with the leave of the court. Now, this moratorium provision is obviously key in affording a company in distress some breathing space in order to regain its financial viability without facing court proceedings against it. But this obviously does have an impact on employees and their ability to enforce their rights and to bring claims against a company under the Labour Relations Act whilst business rescue proceedings are ongoing. Nikita, what are your thoughts on this provision, Section 133 moratorium, and is there a conflict between the Companies Act and the Labour Relations Act in this regard?
Thanks, Juliette. So Section 133 of the Companies Act does, on the face of it, seem to conflict with the dispute resolution provisions of the Labour Relations Act, particularly when you consider that one of the core principles underlying our labour laws is that employment disputes should actually be resolved expeditiously. So there have actually been a few cases where employees and trade unions have tried to argue that there is a conflict between this particular provision of the Companies Act and the Labour Relations Act. And they've tried to argue that employment-related claims should be permitted during business rescue. However, our courts have consistently held that there actually is no conflict between these provisions. And the most recent judgment which confirmed this is the SAA judgment that was handed down by the Labour Court in February this year, where NIMSA brought an urgent application relating to a claim by their members for payment to the same package that had been paid to employees who had settled their claim for arrear wages. Now, the court said quite categorically that there is actually no conflict between this moratorium provision and the Labour Relations Act. And the court's reasoning here was that employees are not actually deprived of their rights under the Labour Relations Act, and they can actually still bring their claims against an employer who is in business rescue. But they just have to do this subject to Section 133 of the Companies Act, which means that they either need to obtain the written consent of the BRP or they have to apply for leave to the High Court to uplift the moratorium. So the court says there's no conflict because employees are not deprived of their rights. They do have remedies here, but they just have to follow what Section 133 says, and they have to either get consent from the BRP in writing or go to the High Court to uplift the moratorium. So there is an avenue here, but you can see how trade unions and employees might actually be reluctant to go about this, because there are additional costs of having to first go to the High Court with a whole formal court application there to uplift the moratorium before you can actually bring your urgent application in the Labour Court. But what the Labour Court has also pointed out is that employees can also just wait until the business rescue process ends and bring their claim then, because their claim is only suspended during the period of business rescue proceedings, in terms of Section 133, subsection 3 of the Companies Act. Now, while this may be true, and while employees might be able to wait until the business rescue process ends, there are some labour disputes that are not meant to be delayed. And when we talk about these disputes, we're really talking about urgent applications that employees and trade unions can bring during a retrenchment consultation process, where they believe that there's been some non-compliance with a fair procedure or the employer is following some sort of procedure that's unfair. And so this claim is in terms of Section 189 capital A, subsection 13 of the LRA. And our court has actually said on a number of occasions that this section, Section 189A, is meant to be invoked so that the Labour Court can actually exercise its supervisory authority and actually bring the consulting parties back on track where they veered, of course. So where there's been some sort of procedural defect, the Labour Court actually wants employees and unions to bring that claim quite quickly so that they can actually just bring the parties back on track. And the Labour Court has actually been reluctant to provide relief under that section in the LRA once the process has already ended and the horse is bolted. So while the court is saying that employees have not actually been deprived of their rights by the section in the Companies Act, you can see from the employee's perspective that there are some practical difficulties here, either because they have to first go to the High Court to uplift the claim, and that's a whole separate application, or they have to wait in circumstances where the court has already said that you should actually bring this claim as quickly as possible.
So,
sorry, Juliette.
Sorry, Ros, yes.
Can I just quickly say something as well that strikes me? The other difficulty, or where there is, I think, a potential conflict, is that the Labour Relations Act specifies that you are required to start retrenchment consultations as soon as you envisage the possibility of retrenchments. Now, if there is a delay in issuing getting the business rescue plan in place, then it may very well be that you have delayed, and that in itself is problematic. So that's just another complexity that is added, because of these two different laws.
Yeah. So what I'm understanding from what you're telling me is that ordinarily, if a retrenchment process was underway and was going, was going sideways, or there was any element of unfairness, employees would have remedies under the Labour Relations Act. But if we take into account these recent judgments, assuming that a business rescue practitioner doesn't consent to employees going to court to bring things back on track, or they don't obtain the leave of the High Court, to some extent, the business rescue practitioner or the company is really protected from unfairness claims during these retrenchment processes. Is there an element of truth to that?
Yeah, I mean, to some extent that is correct. There is some sort of protection during the business rescue process. And I suppose that is actually the point of the moratorium, as you said, to give the BRP some breathing room. But it's important to bear in mind that a court can also award compensation to employees, particularly in relation to this unfair procedure in a 189A. So usually the remedy would have been an interdict by the Labour Court to compel compliance with the fair procedure. So where the parties have gone off track, the court would actually immediately get involved, exercise its supervisory jurisdiction and say, actually, I'm going to compel compliance and you need to actually follow a fair procedure. But it's important to bear in mind that an application can also be made within 30 days after the employer has given notice of dismissal. So what trade unions and employees could potentially do is wait until the business rescue process ends and the moratorium is then lifted. And then within 30 days after the end of that process, then bring a claim for compensation. So I think it's important to bear in mind, particularly for BRPs and companies, is not to think that there can't be a claim down the line and that you've been completely protected from any kind of employment claim. Particularly when faced with a procedural fairness claim during retrenchments, we think that BRPs should really think carefully about whether or not they should actually consent to the claim in the first place and deal with any procedural defects that might have arisen in the consultation process, because this actually might be better than refusing consent and the company potentially having to face a claim down the line for compensation after the business rescue process ends. So there might actually be circumstances where it's better and it would be more practical for the BRP to actually just give the consent up front instead of having to deal with a claim for compensation after business rescue ends.
Yeah, I think it's correct that no business rescue practitioner is going to want to face a scenario where claims for compensation are brought, after business rescue proceedings essentially are coming to an end. And I think in general, most business rescue practitioners want to avoid any sort of litigation, if at all possible, because litigation in the process just delays it and prevents it from being this rapid, this process intended to rapidly restore a company to financial health. And as we said at the beginning, I think for this reason, it's very important to try and communicate transparently with your employees as soon as possible. and to get things moving in the right direction without friction. Adam, do you have anything in particular to add here? I mean, do you think there are circumstances where a business rescue practitioner should consent to giving employees access to the courts?
Yeah, well, just remember, by way of background, that the access to the court, of course, is a high court if the business rescue practitioner doesn't consent. And we've certainly always advised our practitioners, if there's a reasonable request, then that consent should be given. Well, I had one about 2 or 3 years ago where the practitioner refused consent, and it got extremely ugly because an application was brought by the affected parties to the High Court, and it was quite a shock to the business rescue practitioner that the issues weren't only confined to that particular one for which consent was sought. And you've got to be careful. If there's a genuine dispute which requires the intervention of a court, then I would encourage practitioners to provide that consent, the labour court that is, for the commencement of the proceedings. That's only fair.
And when it comes to applying to the High Court to lift the moratorium, there has been some case law about that. And what are the circumstances under which a High Court is likely to lift the moratorium in employment-related disputes, or for that matter, in any other type of dispute?
Yeah, look, I mean, that was dealt with quite recently in the SCA matter, SA Airlink versus SAA. We acted for those nice chaps with the fancy tailplane, SAA. And the court held that the moratorium is applicable in respect of all legal proceedings. Because the point that was raised there was whether the labour proceedings could be affected by the moratorium. The court said yes. And the SCA, where the matter eventually landed up, said that the intention of the moratorium is to cast the net as widely as possible, so that would include any conceivable type of action against the company under business rescue. The court also recognized that the factors relevant in determining whether or not to lift the moratorium are actually case specific. And the court there endorsed the finding in the matter of Arends versus Van der Merwe. It was a judgment of Borchowitz in 2016. As it happened, the matter had been resolved before the judgment, so it was a bit moot, but it has some very useful pronouncements. Because don't forget, the moratorium is not an absolute bar to legal proceedings being instituted or continued. There is the uplifting the bar, the moratorium, which the Act provides for. The court would also have to consider the effect that the grant or refusal of leave would have on the applicant's rights, as opposed to other affected persons and stakeholders. The court was quite insistent to point out that any discretion that the court might have should be dictated by the interests of justice. And then the further consideration was that the impact that the proposed legal proceedings would have on what was referred to as the well-being of the company. That's a throwback from a much earlier case, by the way, and the company's ability to regain its financial health. Lastly, I mentioned right at the start of this webinar that what 7K and 128 provided. And the court said this has got to be in accordance with the objects and the purposes of business rescue proceedings. And those are, as we set out at the start of this, in terms of section 7K, sorry, and 128 of the Companies Act, to which I referred earlier.
Thanks, Adam. Well, that really brings to a close the main subject matter we wanted to run through with all of you, and we're happy to open the floor to questions at this stage. There are a couple of more that have come through. I'm just having a look here. Quite an interesting question. Has SAREPA or any industry body looked to amend the Companies Act to streamline the process? And I assume they mean the sort of retrenchment type process. For those of you who don't know, SAREPA is the South African Restructuring and Insolvency Practitioners Association. It's the sort of most active insolvency and business rescue association in South Africa, and those of us who practice in this area are members, as are business rescue practitioners, insolvency practitioners generally. Many bankers, etc., are also members. And as far as I'm aware, and Adam, you jump in if you know anything more than I do, but SAREPA is constantly lobbying for appropriate changes to legislation which will facilitate insolvency and business rescue processes. But I'm not aware of any specific lobbying around the area of employees and retrenchments. I don't know if you know of any, Adam.
No, I don't, but there is always broad-ranging consultation. But unfortunately, look at the history of this. The Act came in 2008, promulgated, commenced 3 years later, by the time some of the major glitches had been fixed in 2011. And there's been very little consultation since then in terms of amending it, some limited points. But it needs a complete fix, not just Band-Aids, I'm afraid.
Yeah, I would agree. Then one other question here, it says, one could expect that the majority of protections for workers would flow from the Labour Relations Act. Only reading the Labour Relations Act, it seems retrenchment could be possible in terms of the LRA under business rescue. However, the trade union and SAA succeeded by relying on the Companies Act. Are you of the view that the Companies Act and the Labour Relations Act are properly aligned? And if not, how should the laws be amended? I think we've discussed the sort of potential conflicts quite extensively. Ros, I don't know if you have got any ideas there as to how you would like to see the legislation better aligned, or perhaps just giving us greater clarity as to what's possible and what isn't.
Okay, well, I think the Labour Court in the SAA, the Labour Appeal Court, said that there is no conflict. And I think in the judgment that Nikita was talking about, they said there was no conflict. I'm not convinced that's correct. So they might have found in those circumstances it wasn't a conflict. But as I said earlier, I think there is a potential conflict because of the delay. So where you have a scenario where you're required to issue 1893 notices as soon as you contemplate retrenchments, but then you can't issue section 1893 letters until there's a business rescue plan in place. To me, that is a bit of a conflict. I think the court's attitude to that is likely to be, yes, but it's not unfair to employees. So the whole purpose behind commencing retrenchments as soon as possible is so that the employees have as much say in the process and the employees can engage properly before any decisions are made. So I think that's what the court is probably saying when they say, well, there's no real conflict. I think there's, as Nikita also said, the other conflict that we've identified is with the 189 capital A 13 applications, which are aimed specifically at putting retrenchment consultations back on track. So how we go about that, I can't think of much more than what we've already discussed in this. Try and deal with things up front. If you can have your retrenchment process started and hopefully finalized before any business rescue proceedings start, that might be a good option. And where there is a legitimate or valid dispute about whether or not the process is fair, then it may be that those are circumstances where the practitioner should agree to go to the Labour Court.
Yeah, I mean, I think it's unavoidable that there's always going to be a degree of tension between the desire to save a business as quickly and effectively as possible and the obvious desire of employees not to lose their jobs or have more stringent terms and conditions imposed on them. And you can never totally get away from that. I mean, perhaps one possibility would be to provide for a more truncated retrenchment process in cases of business rescue, but that would obviously require quite extensive changes to both the Labour Relations Act and the Companies Act, those to talk to one another.
Agreed.
Adam, I don't know if you've got any thoughts on that. I think, in general, those of us who practice in this space, one of the biggest problems we have is that business rescue is supposed to be a quick process. It's supposed to be limited to 3 months. And in the real world, that so seldom happens. And that brings with it a new set of problems. And as I said earlier, as soon as you get into a litigious space where any affected person is going to court, that whole process becomes delayed, and that just has a adverse impact on the efforts to rescue a company as quickly as possible.
Yeah, I mean, there's another thing that I've been sitting here thinking about, and don't forget, it's perhaps I'm being a little bit cynical, but it very often happens that the business rescue is not there for the noble aim of rescuing the company. It's being used, as happens in some matters, as the last dodge of the desperate debtor, quite frankly. And all the time periods and rules fly out the window when, as you say, you're dealing with litigation. But we've got matters that are years old, not months old. We're in the Supreme Court of Appeal in one matter now, where it's 7 or 8 years. That could never have been in contemplation of the legislature on the 3-month scenario. But having said that, even doing it voluntarily on a pre-pack basis, 3 months is a heck of a push to get all of your ducks in a row before you can actually get out of business rescue. So that was hugely over-optimistic in the first place. We don't have dedicated courts, for example. You want an urgent hearing, you could wait 6 months or 9 months to get it in the normal course. And just as a matter of interest, the matter we were in the High Court yesterday in Gauteng, where affected parties tried to bring an application to put a very, very large state-owned enterprise into business rescue. It wasn't SAA, by the way. And the court, hats off to Acting Judge Swanepoel, who did the matter, said, well, I'm not going to deal with urgency. You're now here. You're ready to run the matter. And he actually grappled with it. But that was something that rang a bell, because the proceedings started in May 2020. So you're talking a year and a half by the time that got to court. And until we fix those sort of things, it goes to the earlier question about repairing holes in the existing road of the business rescue legislation. Until you've actually got the dedicated court up and functioning, where you can go and get urgent relief, you're stuck with these time limits and very little opportunity to be able to truncate them as well.
Absolutely. I mean, you use the word pre-packs. So for those who are unfamiliar with that, in some jurisdictions, it's possible to almost put your business rescue plan together in advance of putting a company into a rescue process, and then implementing it very rapidly so that you only remain in business rescue or whatever equivalent rescue process there is, for a very short period of time. That's not really possible under our laws. And Adam, just thinking about the employment context, obviously you could never pre-pack something with regard to employees. Once again, that would mean it's a fait accompli. You've already decided what you're going to do with your employees, and therefore more than likely fall foul of the Labour Relations Act, which contemplates thorough consultation with employees before you reach any final decision.
Yeah. Sorry, you're on mute, Juliette.
Apologies, sorry. I was just saying there don't seem to be any more questions that have come in. If anyone wants to ask some more questions, won't you please type them into the Q&A and we can deal with them. I'll give everyone a couple of minutes.
But Ros, perhaps we can just explore this one, because it's something that people are asking, particularly in the international arena, on a more and more regular basis about pre-packs. Is there some sort of creative mechanism that you could use to consult with the employees, reach an agreement, and kind of sell that bundle of rights, if I can put it that way, out to your prospective purchaser in a pre-pack situation, or you just have to wing it and hope that you get good faith from the unions in their consultation process?
Well, I suppose if you can get agreement from the employees, then I suppose it would be in order. But once again, it would be going into, I would suggest, some form of collective bargaining, and engaging with the employees and the unions. And then I suppose that could conceivably be some a way in which to solve this problem.
Because I would go to the employees and say, look, the company is in dire financial straits. You've got two options. We either manage to get to a point where a business rescue plan can be approved, and that would include dealing with you, Mr. and Mrs. Employee, or the other option is that it goes into liquidation, where you have no rights, limited benefits and limited dividends, and it's all fall down. I would have thought that's a fairly powerful and cogent way to argue with the unions. We're not prejudging it. We're telling you as a fact that this is what may well happen if we don't manage to bring a business rescue.
Yes, I think that is probably the strongest strongest argument. And I mean, if employees understand what will happen to them when you go, if the company goes into liquidation, that, in my view, would be quite a compelling argument to get them to agree, to change things. It doesn't always happen. I've seen scenarios where the employees just say, nice try, or they don't really believe it. But I do think that, if they really understand what could happen if the business goes into liquidation, then there is a good prospect of getting agreement, especially seeing as, if I'm not mistaken, the retrenchment payments in a liquidation scenario are very reduced. And if you take a voluntary retrenchment prior to liquidation, you're probably a lot better off than if you are to take a compulsory retrenchment in liquidation.
Yeah, in the liquidation, I think the amounts that you get are something like 40,000, 40 in total. That's assuming that there is cash in the business and assuming that the employees have good preference claims. But that's it. Talking 40,000, it's peanuts.
No, absolutely.
Yeah.
I mean, in terms of the Basic Conditions of Employment Act, it's a minimum of 1 week for each completed year of service. And that can rack up for especially for your higher earners. And it may very well be that if you appeal to their pockets, employees will be more willing to properly engage, to try and find proper solutions to save the business, or to say, well, look, you know what, I'm gonna get out now. I'm gonna get out and take my money, and just deal with it that way.
Yeah, I mean, the point is that if you want to play chicken with a 16-ton Oshkosh truck, you better step out of the way before it drives over you, because you're not going to come out up on the upside either. That's just the way it is.
Absolutely.
So, touch of realism for those negotiating for the employees would be useful.
I see a comment that's come in from someone who I know is intimately familiar with the SAA business rescue. And the comment there is, I think the key is that employees don't understand the process nor the dire nature that business rescue is, i.e. the financial constraints, may be more comms to employees. So I think, yes, that just echoes what we mentioned from the beginning, is that it's a stressful process for employees. They don't understand it particularly well. And business rescue practitioners and management, I think from the get-go, need to be sure that they communicate openly with employees, that they help them through the process. And in my experience, in many companies where employees understand the reality, they are willing to pull in the right direction. I mean, after all, the purpose of business rescue, Adam, as you've, I think, mentioned, is to rescue the company in a way that balances the rights of stakeholders. Now, that means creditors and employees, and sometimes it does mean there needs to be a little bit of give by everyone, including employees. And I think most people faced with a liquidation and losing their jobs would rather perhaps, take less pay or something like that, if it is in the interests of rescuing the company and saving their jobs. But that requires the correct way of communicating and avoiding too much friction, I think, from the beginning, so that you don't have employees backs up and being all aggressive from the start. But it is possible, and we've all seen it work in many instances.
Yeah.
Okay, I don't see, oh wait, there we go. We are having some more comments coming in, some more questions. Let's see. This is going back to Adam's comment. Business rescue applications are inherently urgent. In my view, would it not be appropriate for the uniform rules to be amended to provide for their hearing in urgent court? The need to prove urgency is, in my view, misplaced, since each day that passes diminishes the chances of rescuing the business. Yeah, I mean, many of these applications are heard in urgent court, and some judges will accept that any insolvency or business rescue proceedings are inherently urgent. But I suppose it's the degree of urgency. I don't know if you want to comment on that at all, Adam.
Yeah, look at the matter that we were in court on yesterday, with the court saying it might be urgent, but it's not commercial. It's commercial urgency, and that's not good enough. There's no blood on the floor. The chickens aren't dying. The kids are not leaving the country. If you come today, tomorrow, or next week, you're still going to get your relief. And the question of urgency is relative. But don't forget that the Companies Act makes provision for the appointment of a specialized court to deal with these sort of matters. I'm not aware of any jurisdiction that actually in South Africa that has one, but it's there to be used. And to me, that would be the ideal way to kickstart a process. If the litigants knew that they had the opportunity of coming before a court in 24 or 48 hours, or even a few days, I think that would do immense good to the business rescue process and its acceptance by the affected parties.
Agreed. Here's a comment from Elise Engelbrecht. There are rumors about a new Insolvency Act. Do you know if Labour is also addressed in the new considerations, and liquidation might in the long term not be a negotiation tool? I know there's been talk for decades literally about a new Insolvency Act coming in. I'm not aware personally whether it addresses labour issues. Adam, do you have any knowledge of that?
No, I'm just laughing because we made submissions on the new insolvency bill in 1998, and it's still around somewhere. We did a lot of work on it from the private sector side of things. But although we're told that there is a new bill in the offing, I had no insight as to its content. So I suppose the message there is, Elise, you and me better just hang in until the new legislation is ready to be promulgated.
And I suppose the reality is, given the political context, there's always going to be an effort to save jobs. And if anything, I suppose the rights of employees might be strengthened, but we'll have to watch that space and hope that they still balance the need to rescue companies and have efficient processes with the rights of employees.
Yeah.
Okay, I don't see any.
I actually just wanted to add to something that Adam said. Adam, you mentioned that the Companies Act actually makes provision for specialized courts to deal with these matters, and that it actually hasn't been put into practice yet. But do you think if that actually did come into effect, that Section 133 would then be amended to say that parties can actually go to that specialized court to uplift the moratorium? I think that would make sense, because apart from the cost factor for employees and unions having to go to the High Court first, I imagine that also creates a delay, because as you said, it's difficult to get a date in the High Court. It's much easier actually in the Labour Court to get an urgent date. So do you think that if we did have a specialized court, that Section 133 would then have to be amended and employees and unions could actually go there instead of the High Court?
That would be ideal. I mean, that's the whole point of the specialized court. In the USA, for example, where you've got here in Southern District, New York, there was a matter involved fairly recently. And the courts hears all sorts of matters, but they're all insolvency and restructuring based. And the judges are virtually at the disposal of the litigants. They do an amazing job. And if we had that, I think it would resolve a lot of the issues. The one that you raise is very interesting, of course, as well, whether you'd need to go the whole tortuous route of getting leave when you can approach that dedicated court for the relief that you're seeking. I think that's a stunning idea.
Agreed.
Okay, no more questions have come in, so I think that's probably sufficient time. Thank you everyone for staying with us. I see a lot of you have. We've still got 57 people watching. I hope that was helpful and that you've learned a little bit. Please feel free to send in any questions if you'd like to after this. And the recording, as we mentioned, will be made available to all of you if you are wanting to have a look at anything we spoke about. Thank you, everybody. I think that brings this webinar to an end.